in these circumstances, there's an option that might be suitable for you, and it's called a writ of mandamus. And what a writ of mandamus is actually when you go in and you file a lawsuit against the government agency that is unreasonably delaying your case.
I've heard so many stories of immigration cases taking so long to finish, and there's even news articles about it. What can they do?
It's a great question. I've addressed this. I've talked many times about different options that someone can take if their immigration case is taking too long. There's premium processing, which is this optional service where you pay additional money to USCIS and they'll process your case faster. For certain case types, it's available. And then there is making an expedite request in certain cases where there might be an emergency or something where you can ask, hey, can you please speed up the processing of my particular case because whatever the situation is, assuming that it qualifies as one of the reasons to make an expedite request. And there's various ideas in terms of making service requests with USCIS, which is like when you're basically like checking in with them. And those all serve their purpose, assuming they're the appropriate action to take. What do you do if you file a case and months and months and months, just a very long period of time goes by and there's no action on your case? Or let's say you're doing a marriage-based green card case and you basically finish everything and you do the interview toward the end of the process. And following the interview, you're supposed to get a decision one way or the other. And you just wait and there's no action taken on your case. What do you do? Same as if you're applying for citizenship and you file your naturalization application and you go to the interview towards the end of the process, you take your civics exam, you have your naturalization interview, and then after that, you don't hear from immigration any longer for months and months and months. What do you do in that situation? Or another thing that unfortunately a lot of people experience is they'll apply for a visa and they'll go in for their visa interview, and following the visa interview, their case will get put into something called administrative processing, which is just basically this limbo where the applicant for that visa is just waiting for whatever sort of security clearances or whatever it is that the consulate needs to issue that visa. The applicant is just waiting. And what do they do in that situation? They can follow up in all these contexts that we talked about, whether it's for the marriage-based green card case or the naturalization case, or even the visa application. They can follow up with the earlier examples. They can follow up with USCIS. They can call the hotline. They can email whatever they think they might be able to do in the context of a visa application. They can email the consulate and say, hey, any update? Any update? My case is in administrative processing. I haven't heard anything. It's been several months. But usually when you follow up using these methods, isn't really fruitful. You'll just get a boilerplate response back. In USCIS, it might be like your case is still within standard processing times, or we'll get back to you in 60 days. Or in the context of when you're reaching out to the embassy or the consulate, they'll give you a boilerplate response. Your case is in mandatory administrative processing. We can't give you a timeline on how long this is going to take. So your case is just stuck and you want to know, what can you do? Well, in these circumstances, there's an option that might be suitable for you, and it's called a writ of mandamus. And what a writ of mandamus is actually when you go in and you file a lawsuit against the government agency that is unreasonably delaying your case. So it's a lawsuit that's filed in federal court where you're essentially asking a judge to compel the government agency to take action on your case. You're basically saying, look, my case is being unreasonably delayed here. I need help. You're asking the judge to compel, whether it's USCIS or the State Department, to make a decision. And this method, this writ of mandamus, has proven to be a very powerful option to speed up your case. In many cases, when someone files one of these writ of mandamus lawsuits, what will result is that your case will be worked on. Your case will essentially move forward. It's a great question. It's a very common question, is how long do I have to wait before I file my writ of mandamus? When you're filing a writ of mandamus lawsuit, you're essentially putting forth this claim that there's been an unreasonable delay in the processing of your immigration case. So what's unreasonable? And a lot of people think my case is processing within the posted timelines of USCIS. So USCIS, they have a dedicated web page based on the specific case type that you're filing. They'll post a time within which 80% of cases are adjudicated within. So it'll say, okay, you put in, I'm doing an I-129F, a fiancé visa petition, and I'm filing it in this location. And then you enter it and submit it, and then it will tell you the average timeline within which 80% of that type of case get processed within. So one thing that I want to mention, you might be thinking that if your case is within that timeline, that it's not an unreasonable delay. But I would argue that when you're filing a writ of mandamus, what's considered reasonable versus unreasonable is not based on USCIS's stated processing times. That's up to a judge to decide what's unreasonable. What I would say is, if you have a case that's pending with USCIS and it's been pending with USCIS for a year or more, I would think that that would certainly be worthy of exploring whether a writ of mandamus could be appropriate for you. So I also want to know more about personal circumstances that are going on in your life. How is this delay impacting you financially? Are there certain things specific to you that are making this delay particularly strenuous? Whenever we assess whether writ of mandamus is an appropriate option for you, we really want to know your particular circumstances. But what I would say is that if your case has been pending with USCIS for a year or more, I would say that it's certainly worthy of exploring whether writ of mandamus could be a good option for you. Now, let's say that your case is pending with a consulate abroad. Let's say you had a visa interview and you've completed your interview. Now you're stuck in administrative processing. And let's say your case has been in administrative processing for a month. Well, I wouldn't just look at the delay from the time you've been in administrative processing. I want to know from when you first filed something regarding this particular case until now, how much time has elapsed. So let's say that you're doing a marriage-based green card case, and the first part of the process was filing a Form I-130 with USCIS, and then that got approved, and now you're at the stage where you're applying for an immigrant visa at a consulate. Well, when I'm analyzing this unreasonable delay, I'm not just going to look at this segment of time that you've been in administrative processing following your visa interview. I want to start the clock at the time you filed that I-130 with USCIS over a year ago. And I want to make that argument that there's this huge block of time that this case has been essentially ongoing, and using that as the basis to frame this unreasonable delay. So I would say in the context of a case that's been pending with a consulate, again, it's a very fact-intensive analysis, and I would want to know your particular circumstances, but I would say that if your case from the time you first filed a petition relating to that particular case until now has been about a year and a half, and it's now with the consulate, I would say that that's certainly worthy of exploring whether a writ of mandamus could be a good option for you. Determining whether a writ of mandamus is suitable for you, there's a back and forth where I want to know more about the details of your case to be able to make that assessment. But I would say that these are cases that require familiarity and know-how in this particular area, because again, it's not your typical run-of-the-mill immigration. It's a lawsuit filed in federal court. And it's important to work with somebody that focuses on this specific thing, on this specific area of immigration law. So we do it at our firm. This is an area within immigration law that we focus on. And I would say that if anybody wants to know whether they could be eligible for this, we would be happy to speak with them. We offer complimentary consultations in many cases where we can look at the facts of their particular case and we can give an assessment of whether we think it could be a good option for them to pursue. At our firm, the writ of mandamus is a service that we offer. It is a service that we focus on. If somebody's out there and wants to know whether they qualify for this, I would invite them to schedule a complimentary consultation with our team so that we can explore this further and see if the writ of mandamus could be the appropriate route to take.